My name is Parna Marabani. I'm a partner here at Tonkin. I'm the co-chair of our firm's intellectual property practice group, as well as our IT and data security practice group. This is our webinar on the California Privacy Rights Act of 2020. Joining me is my colleague, Alexandria Wagner-Jakubiak. The California Consumer Privacy Act of 2018 has been in effect since January 1 of 2020, and it was enacted by the state to protect the personal data of California residents. For those of you that came to some of our prior presentations on the CCPA, you might recall that it was sort of a negotiation between some consumer rights groups and the legislators. It was drafted very quickly. It was amended several times. It was slightly a mess, I'm going to say, in my opinion. We thought that was going to be it. And then those consumer rights groups got back together and they passed the CPRA by the initiative process in California. So that's why there have been so many changes to this in such a short amount of time. So the CCPA's purpose is to protect California residents' personal information. And as many of you may know already, it imposes various data protection duties on certain businesses conducting business in California. And we'll get into who's covered in a minute. Many of those duties you may be familiar with. They include, for example, providing and updating privacy policies, ensuring that personal information that is collected, used, or shared is reasonably necessary and proportionate to the collection purposes. It requires responding to consumer rights to access, delete, and correct their personal information. And it also requires that you use simple and clear methods when you provide choice options to consumers, responding to consumer rights requests, or obtaining consumer consent in the first instance. And just to be clear, when we say consumer, that is a California resident, household, or device. So all of these references to consumers are specific to California when we're talking about the California law. So what is personal information under the California law? Again, just a reminder, as this has been in place for some time, the definition of personal information is very broad. It means any information that identifies, relates to, describes, or is capable of being associated with, could reasonably be linked directly or indirectly with either a particular consumer or household. So this is a really broad definition. And personal information does include information about employees, and it does include information that's collected in the business-to-business context. So for example, if you have a vendor that's in California and you have the contact information for the employees of that vendor, that is all personal information under this statute. The CCPA previously had a 2-year exemption that excluded employee and business-to-business information, but that exemption is no longer available now that the new CPRA has gone into effect. So just very quickly, personal information includes, I'm going to have a list up here. You'll see the list there. I'm not going to read through all of it, but you can see it's a very broad list. Most importantly, it does include things like internet browsing history, that you might not consider personal information and it might be automatically collected by your website. It also includes inferences from other personal information that could create a profile about a consumer's preferences and characteristics. So again, that's information that you may be collecting on your website via certain online services that is considered personal information, even if it doesn't include something uniquely identifiable like a social security number and email address. Personal information does not include, under the California law, information that is sort of publicly available, so things that are in government records, for example. And it also does not include de-identified or aggregated consumer information. So if all of the personal information you have is de-identified or it's aggregated, then it doesn't fall under this definition. And then finally, moving on to enforcement, violations of the CCPA are currently subject to enforcement right now by the California Attorney General. And those include fines of up to $2,500 for each violation. And then those fines can be increased if the violations are intentional. That is after you get a notice and you have a 30-day opportunity to cure. If you continue violating, then those fines go up. And also there are higher fines if children are involved. A few things about enforcement. These enforcement will change starting July 1st, 2023 under the CPRA, which is the newer provisions. There is no longer a notice and opportunity to cure starting July 1, 2023. And also the CPRA creates another route of enforcement because it establishes a new agency in California that's going to interpret and enforce the law. That's called the California Privacy Protection Agency. That is going to be the first US-based regulatory authority that's focused exclusively on investigating data privacy issues. So they're going to take over the rulemaking power from the Attorney General and then also doing the hearings and fines and things like that. Also really important to note, there is no consumer private right of action, which means an individual person doesn't have the right to sue you under this law. With that said, lawyers can be very creative. So I wouldn't put it past a very creative California plaintiff's lawyer to find a way to get a private right of action using some other claims or perhaps under some sort of unfair trade practices type of theory or something like that. So we haven't seen any of that yet under the CCPA, but it remains at least a small risk under the California regime, at least for now. But there's nothing directly in the law for a private right of action. All right, so I'm going to stop there briefly if there's any questions before we move on to the California Privacy Rights Act. Any questions at the moment?
Nothing in the chat at the moment.
Excellent. All right, Alex, let's move on then.
All right, so that brings us into talking more about the CPRA, the California Privacy Rights Act, which went into effect January 1st this year. But like Parna has talked about, enforcement does not start until July 1st. There is a look back period that goes all the way back to January 1st of last year. So that means when consumers are requesting information or otherwise, utilizing their rights, you're going to be a business is going to be responsible for looking back at information collected since January 1st, 2022. So that's something to keep in mind. Also, the agency that we just talked about, they're coming out with some more regulations pretty quickly, actually, and they're going to be harmonizing the CCPA with the CPRA. So if there's some confusion, they're going to work on giving us more clarity and specificity when it comes to certain things like cyber security assessments that might be required by a business. We will webinar on this when we have more information. We expect to start getting that information at the end of this month, and we'll be happy to share as we get it. So who is regulated? This is, one of the most important questions of the day. I'm going to be calling regulated organizations covered organizations. And essentially the test is going to be, this applies to a business if it is a for-profit business that in any way collects, sells, shares California residents' data. And then you also, in addition to meeting that, you need to meet one of these three thresholds. So the first is that you make 25 million in gross revenues, not just related to California, but holistically. Or you possess the personal information of 100,000 or more consumers. This threshold was raised from 50,000, which was in the CPA prior. This is for the year, it's in in an annual year period. So as you are collecting information, you only have to capture the snapshot of a year. Same with that annual gross revenue, but we look back to the prior year to determine that. And then lastly, the third threshold is if you earn more than half of a business's annual revenue from selling the personal information. And selling has a broader definition than you might think. It's not just about transacting, selling data to an advertiser for money. This is really any sort of transfer of data that a business collects on California residents that otherwise meets the first part of the test on the other slide, and doing it for any sort of monetary gain or other value. So an example is that the other value could be if you're working with a third party that takes the information you capture from your website and then puts the business's ads onto other places using that information. That is a benefit derived to you that may not be exactly the same as money changing hands.
Alex, we have a question in the chat, which is the 100,000 person threshold limited to Californians? And the answer to that is yes. So yes. That reference to consumer is 100,000 California residents data. And just to put that into context, if you have Google Analytics on your website that collects visitors' information from your website, 100,000 consumers means about 274 people a day from California visit your website. And if you collect information about those 274 visitors via Google Analytics, then you may reach that 100,000 threshold. But if that number seems like a really high number for you of people visiting your website, and even higher if we have to limit it to California, then you may not fall into that threshold amount. So we're going to stop there. And I do just want to reiterate that when there are going to be regulations coming out in California, and our goal is to continue to update you on this information and give you updates on those regulations as well.